Grief hits a family the exact moment a loved one passes away, bringing a heavy emotional weight. But almost immediately, it collides with practical realities. In Ghana, the cultural response to death moves at an incredible speed. Family meetings are called, and the traditional one-week observance is organized in a matter of days. But while the funeral planning accelerates, the deceased's legal estate comes to a complete, sudden halt. Everything from a family house in East Legon to a cocoa farm in Ashanti, rental income, and even business accounts are instantly locked in a legal vacuum. Banks and institutions require proper legal authority before releasing a single CD. This leaves families facing mounting funeral expenses right when they are entirely cut off from the estate's funds. Escaping this financial freeze depends entirely on one question: did the deceased leave a valid will? This diagram illustrates how Ghana's Wills Act classifies a document. To be valid, the maker of the will, known legally as the testator, must be at least 18 years old, possess the mental capacity to understand their actions, and put their instructions in writing. Looking closer at this final checkpoint, the strictest requirement is the signature. The testator must sign or acknowledge their signature in the simultaneous presence of at least 2 witnesses, who must then also sign. The estate is now classified as intestate, meaning the deceased left no legal instructions behind. Without an executor chosen by the deceased, the family is forced to apply to the courts for letters of administration. This is a formal document granting specific individuals the authority to manage the property. This alternative path takes significantly longer. The courts require public notices, leaving the door wide open for relatives to raise objections. This diagram maps out how Ghana's intestate succession law applies to complex family structures. When customary marriages, multiple households, and extended family land rights intersect, fierce disagreements quickly emerge over who actually holds the legal right to administer the property. Dying intestate removes the deceased's voice entirely. It leaves the family facing months of locked assets, legal delays, and deep internal divisions. Whether a family is heading toward probate or applying for letters of administration, strict early organization is the only way to navigate the system. The immediate steps are highly practical. Relatives need to check if a will was deposited in court, then gather the death certificate, the required identification cards, and all property and bank records. There is one absolute rule for grieving families: do not divide, share, or sell any assets before the court officially grants legal authority. Keeping the emotional decisions of the funeral entirely separate from the legal decisions of the estate prevents irreversible mistakes and maintains trust across the wider family. Managing these documents while planning a burial puts extreme logistical strain on a family, especially when a daughter in London is trying to coordinate with a son in Accra. When you want to be supported in a difficult emotional time, the Ghana Memorial Platform offers a practical solution. Its Funeral Planner Guide is designed to centralize information, coordinate relatives globally, and relieve the intense pressure of early organization. Families can even prepare ahead using the Ghana Online Willmaker, ensuring they establish a clear legal voice and never leave an intestate burden for their children to unravel. By integrating modern tools like mobile money donation links and QR-coded funeral brochures that connect to lasting digital memorial pages, the platform blends traditional dignity with global accessibility. While the traditional funeral concludes in a matter of weeks, Ghana Memorial preserves the records and the remembrance for the generations that follow. It provides the digital legacy every Ghanaian deserves, ensuring families can honor their loved ones while securing their future.